show.
That's right. She's done like dozens up to this point. Hello.
Hello. Hello.
Hello. It's
Hello.
a surprise. Alice is here.
Wait, can they hear us?
I think so.
Oh.
I don't know. You know, it always takes like a few seconds for people to start
Never.
responding.
I always forget that there are people watching.
Well, they've only been watching for the last 20 minutes, or 20 seconds.
What? What?
There
Oh
they
my
go.
goodness.
Now they're coming through.
Hi, everybody. Hi.
Hey.
I'm
Alice,
really
you have
liking.
to.
Oh, do you hear that? Do you hear
No,
that?
that's the baby.
That's the baby, you guys. Wait, let's see if I can show the baby.
Show the baby without, remember, this is on YouTube. So
This is the
it's not-
baby. Okay, covering her back up.
Anyway,
Hi,
you can
everybody.
bring the baby out all you want.
Yay.
Don't forget, Alice, you have to do the intro because this is a legal brief.
That's right. I need to think of. Okay, I got you.
Okay.
Welcome back to the legal briefs. I
It's
forgot
been so
how to do
long.
it.
It's been so long.
It's been so long. Okay, I literally couldn't remember the name of the show. Oh my goodness! I have not been drinking, y'all. Okay. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my ever-supportive co-host, Brett.
Hi, Alice. I'm so excited to see you and hear you and be on the podcast with you. I mean, you've been waiting to have this baby for weeks and weeks of podcast time.
This
And here
baby
we
took for like 21 months, you know?
I know. This baby came out speaking.
Walk right out. It was super easy, y'all.
Yeah.
Oh my goodness. No, so you guys are seeing history in the making. Brett and I have not recorded since this baby came along. I have barely seen Brett's face, and I've missed your face, Brett. I've seen your wife's face way more than your face. So I don't know what that says, except that I love Mrs. Brett. And for all of you wondering, yes, her name is Brittany.
Yeah, just like her dad.
And and if you want to know if I'm joking or not, I'll tell you on Saturday.
Oh wow! There you go.
I think she just told you.
Yeah, little Brittany's like
that her name's not.
Okay,
that is
not my name.
We're gonna remove Brittany, and I'll be right back.
You know how to do that? You do what you need to do, Alice.
I'll be right back.
I'll introduce the case while you're
okay.
handling. As if anyone needs introduction here. That's funny. She just kind of completely disappeared. So, why are we here? I think all of you are probably aware at this point that there's been some pretty big news in true crime. Probably the biggest true crime case of all, Adnan Syed versus the state of Maryland, involving the murder of Hae-Min Lee, for which Adnan Syed was convicted some 24 years ago, 23 years ago now. I'm not exactly sure when he was convicted. The murder was 24 years ago. In any event, Alice is back. Several months ago, there was a decision by a Baltimore City court at the behest of the local prosecutor's office, the local office of the state's attorney, to vacate that conviction. And this came about through a statute in Maryland that allows prosecutors to seek to set aside a conviction that they believe has problems, that they believe has some sort of fundamental errors or unfairness or unconstitutionality, whatever the case may be. And then after that, they have 30 days to decide whether or not to retry. And shortly thereafter, only 2 or 3 weeks later, the state decided to null pros the charges against Adnan Syed, and he was a free man. He went off. I've seen Instagrams of him shopping. He got hired or in some capacity at Georgetown University talking about wrongful convictions, and he sort of went on with his life. But at the same time, there has been an appeal of that action, and the appeal was actually by Hae-Min Lee's brother, and he, as the representative of his family and the victim, had filed an appeal saying that the statute was not followed, and specifically that the victim's family was not allowed their right to appear at this hearing and sort of take part in a meaningful way. And some of you may remember when this initially happened and Adnan Syed's conviction was vacated, we immediately did an episode on it. I don't know that we did a live episode. I think that might have been pre-live episodes.
That was pre-live, but we had a lot of thoughts. We probably didn't need to be live because there were a lot of hot takes that probably needed to be edited out. Thanks to Jason.
Yeah, it was about an hour and a half long, and it was. And as we've always told you guys, we just tell you what we think. We're always going to give you what we think. We're not going to tell you what's popular. We're not going to tell you what everybody else is saying. And the first thing we said was it wasn't about his guilt or innocence. And today is not about his guilt or innocence. It was about whether or not the law was followed, process was honored, the judicial system functioned in the way it should to protect both defendants and victims, and whether or not this person who had been convicted by a jury of murder, whether the process that released them was a fair and just process. And we had a lot of problems with the process, and we complained a lot about it, and we got a lot of blowback, which we expected from people who said who were all about the final outcome. Adnan Syed is innocent and it doesn't really matter. Y'all talking about process. We're talking about justice and all this other stuff. And in that episode, we warned people that if you don't follow the process, bad things can happen. And I think we even said at one point, it would have been better for Adnan Syed, not to mention Hayman Lee's family, if they had taken the time to do this correctly, to follow the law, to do what they're supposed to do. And if they had done that, we would not be where we are today. If they had done that, this never would have happened.
Point on that, Brett, when you said that there seemed to be this false dichotomy that it was either about justice or about process. The thing is, as we have said time and time again, due process is written into our Constitution. Due process is what our entire judicial system about. It is actually the process that affords justice. And so this false dichotomy that a lot of the Redditors or those watching in were trying to make was actually false, because the lack of process is actually what leads to injustice.
Yeah. And look, I just think it's really important before we even get into this, and we're going to talk a lot about this, but before we even get into it, a lot of people talk about, ethical podcasting and ethical true crime, and they always focus on the victims. And we get people who complain. Alice laughs once in an episode, and that means that we're not respectful of victims, we're horrible people, and we should all die, right? Well, to me, part of respecting the victims is in a case where your favorite defendant is appearing, even if you really believe that person is innocent, respecting the victims enough to follow the law, to allow them the rights that the law affords them, and then to move forward. And really, I think that was all we were asking for. This appeal happened. A lot of people scoffed at this appeal. They said, this is over. You can't do this. There are going to be double jeopardy problems. What can they do? It's not like they can go back and do this over again. And that's exactly what happened. Today, the Maryland Appeals Court, in a 2-1 decision, essentially voided everything that happened in this case. So just to give you sort of where we are, because I know a lot of people were really confused about the procedural thing that happened here. First step was the state voided Adnan Syed's conviction. After that step, they then dismissed the charges against him. Here's the thing. In the law, we have something called void ab initio, right? And what that means is something is void from the get-go. And everything that happens in it is a nullity. It doesn't mean anything. It didn't even happen. And so in this case, what the appeals court said was, by not allowing the family time to meaningfully participate in the hearing, to attend the hearing in the way that the statute requires, everything the court did from that point forward was void. So it was void when they vacated the conviction. It was void, and the prosecution cannot dismiss the charges until the conviction is voided. This is an important thing. As we've said before in other episodes, prosecutors have vast authority at the beginning of a case about what charges to bring, and then their authority declines over time. Even if we want to dismiss a count, we have to do it with a leave of court. After we've charged it, after a grand jury has found probable cause, the prosecution can't just dismiss it. The court has to allow it. After a conviction, after a jury has returned a verdict, the power of a prosecutor to do much is really at its lowest point. And they needed the court to vacate that conviction so that they could dismiss the charges. Since the court's vacation is invalid, the charges are no longer dismissed. And so we're back in the same place that we were at before that hearing even happened. Yesterday, Adnan Syed was an innocent man. Today, he's a convicted murderer as far as the courts are concerned.
That was such a good explanation, Brett. And if you are an image person, think about a set of dominoes. Basically, the court is going back to the first domino that fell and saying because that was invalid, that domino essentially was never pushed over. So all the dominoes that fell in subsequent nature in this case at the lower court didn't happen at all. So there's no double jeopardy issue. It's a great read. It's a very educational read to read what the court issued today. But one thing to note, just because I know this gets lost a lot, the way the prosecution went about dismissing the charges in this case was completely outside of process because remember, there were other processes in place even after the conviction by a jury. There were all of his appeals, which he had access to. The conviction had been affirmed on appeal multiple times. So this is not a situation where he hasn't had every possible avenue through the law to contest his conviction. He has. And what the prosecution thought was a loophole, the appeals court is knocking them down and saying, absolutely not. There's no exception that swallows the entire rule. Otherwise, imagine no finality to just about any type of trial. And it's the right decision. This is correct. Again, this has nothing to do with his guilt or innocence, but there are processes in place. And with respect to the processes here, it's that the victims, and there's a statute here, in Maryland, and I think almost every state has a similar statute. I know in all the states I've lived in have a similar statute where the victims' families, especially if they're victims of murder, they're no longer around, their stand-in, have a say in what happens in terms of hearing what the reasons are, having everything be transparent. The problem with this vacature and then the dismissal of the charges is that we were all in the dark. It was really a one-liner. Charges dismissed. There was no explanation of what had changed since the conviction and the appeals that, affirmed the conviction. And the judicial system is not built to be a black box for the public. There are a lot of things that are black boxes. Investigations are black boxes until, the grand jury votes to indict. But once a case has been indicted, it is on the public docket and is not sealed. The public has a right to know what's happening. And the opposite of that has happened here. Utter black box. And it really undermines the entire judicial system when a prosecutor's office is able to do that.
And it's really, I advise all of you to read the opinion because the opinion is really interesting for a lot of reasons. So we've talked about what happened. We're going to talk about what happened next. Don't worry, a lot of you are asking questions. We're going to talk about that, why it happened. But we're also going to talk about some of the other stuff in this opinion, which I think is interesting, which requires you to read between the lines a little bit. Before we get to that, though, I advise you to read this because this is a brutal condemnation in so many ways of what happened. The court is very careful to say, and we talked about this before. We talked about this in other cases where there is one issue before a court and the court goes out of its way to point out other things, which is really sort of sending a signal, right? So the court makes it very clear that the only issue before them is whether or not the family's right to meaningfully attend the hearing was violated or not. And that's the only issue. Really, all it comes down to was telling someone who was in California on a Friday, hey, we're going to have a hearing on a Monday to let your sister's convicted killer out of prison. Was that sufficient? That's really the only question. And they could have just that's all they could have talked about. And they mention at one point that that's the only issue before them. But they say a lot of other stuff. And one thing they point out is so much of the discussion about why they were going to release him happened in an in-camera hearing that was not transcribed. And in the opinion, they say, we can't even say what all happened in there. We're having to rely on the recollections and the good faith statements of the attorneys who were in the room when this in-camera, unrecorded, off the record discussion happened that the judge then points to as the reason she's going to vacate the conviction. And I think that goes to sort of what Alice is saying, that these things can't happen in secret. That is not the way our system works. And even if you liked the outcome here, you're not going to like the outcome in a lot of cases. And I think you can imagine how that sort of precedent and doing things that way could very quickly be abused in a lot of ways.
And let me just kind of show you how seriously the prosecutor's offices are supposed to take this open to the public, nothing in the dark situation. Almost all jurisdictions have some sort of hierarchy where if you want to seal the courtroom, in other words, the public cannot know what's going on, there's some appeal to higher authority within your office. Like the line attorney typically doesn't just get to willy-nilly decide, I'm not prepared for this witness, so I'm just going to seal the courtroom because I'm going to look really dumb to the public. You can't do that. There's usually an appeal to someone above you in the prosecutor's office, or maybe if it's a larger political body, someone in the government, where you have to appeal to and make your case as to why the court needs to be sealed from the public. That's how seriously prosecutors' offices take this open to the public right for the public.
So we'll get into the substance of this in a bit, but let's just walk through sort of the legal issues, because I know that's something that at least some of you are interested in. So there were a couple problems for the family in their challenge. So one of those problems was there was an argument that this was moot, that this was something that had already been decided, and therefore the appellate court didn't actually have the power to do anything. And that was based on the fact that this vacatur happens. Young Lee, who is Hae-Min Lee's brother, files a motion or an appeal, essentially with the appeals court, saying, "Hey, I was not allowed my rights as a victim. I would like to do this again and have the opportunity to participate in the way I was supposed to participate. And oh, by the way, I'm filing a motion to stay any decision in the state court so that nothing else happens, so we can decide were the victim's rights violated or not." Well, what the state's attorney's office did under Marilyn Mosby, who's currently been indicted and facing trial for several federal counts, and in fact, a little craziness in that case, her entire defense team quit, so the trial got delayed. In any event, what she decided to do was just go ahead and dismiss the charges in an attempt, before the trial court could enter a stay, go ahead and dismiss the charges in an attempt to moot the appeal. So basically, well, charges are gone, nothing to restore. I guess you're just going to have to dismiss that appeal. And
talk about
the
gamesmanship,
first question,
by the way. I mean, no one who can objectively look at that would see that as not gamesmanship by, the kind of what you see as the most powerful charging body within a district. I mean, and if that doesn't give you kind of a bad taste in your mouth, then maybe we need to rejigger like your sense of justice, because that should not be happening in this instance. It's certainly not for political reasons or kind of for personal gain to, I don't know, curry favor with the public or the court when you're facing your own charges.
And so she does this. And the first question that the appeals court is faced with is, does that work? Can you do that? Can you just decide, well, sorry, appeals court, if we did it wrong, we did this in secret, we didn't follow the law. Now this person's trying to appeal. How dare they? Well, we'll take care of them. We're going to dismiss the charges. Now they can't even appeal. So, their rights were violated, and they have no recourse. Tough. Go on with your life. This is how they're treating victims. So the appeals court says, can't do that. And they cite to all sorts of Maryland decisions that are other times something like this has happened. Usually the prosecution doing it to screw over a defendant, dismissing charges to avoid an appeal, dismissing charges to deal with speedy trial issues. And there are all these principles that you cannot act in this way to avoid appellate review. And so they say, we're not going to allow you to do that. That did not void the issue. The issue can go forward. It's not moot. Interesting, the dissenting judge sort of didn't agree with him on that, but agreed the issue was important enough, it should go forward anyway. So the dissenting judge agreed with the two that, yeah, we need to hear this. That can't avoid appellate review. He basically said this is an issue that could repeat. It could come up a lot. And because of that, we have an interest in deciding this issue.
And by the way, that matters because In the law, you have to have a case in controversy before you. You may have heard that term and have no idea what that means. A case in controversy basically means you don't get an advisory opinion from the court. You can't generally say to the court, this situation hasn't happened, but I want you to tell me what would happen if I were to violate the law in this way. The court is supposed to step in when there's an actual conflict. But the workaround there is if there's not an actual conflict in that case. And by the way, this is what Roe v. Wade was decided on, because when Roe v. Wade made it up to the Supreme Court, and we're not getting into like an abortion debate here, but this is showing you getting around the case in controversy. By the time that case actually made it to the Supreme Court, 9 months had passed, right? There wasn't an issue anymore of the doe being pregnant. But what the court said is we have to talk about this because this will repeat, and it's always going to basically evade review, because you can always game the system in this situation. You can always dismiss the case to get around, to get a case to be mooted so that the court can never weigh in. And they're saying you can't games the law that way, prosecution, so this can repeat, and that's why we get to rule on this even if there's not a case in controversy before us. And that's a really important point of law that comes up time and time again across state court, federal court. You'll see this in some of the most interesting and important cases of our time, where either side is trying to moot out the case to avoid an opinion, to avoid a higher court from weighing in. And this is the hook to avoid that sort of workaround.
And so what the court ends up saying, and I'll just read what they wrote because they're more eloquent than we are. By entering a null pros while a motion to stay was pending, so the null pros is what dismisses the charges. And while the state still had more than a week before Rule 4333I required action, so basically they had a certain amount of time after the conviction was vacated to announce whether they were going to try Adnan Syed again or not. And when they did this, they still had time. The state violated the requirement that the entry of a no pros conform to the rudimentary demands of fair procedure, and it resulted in an injustice to Mr. Lee. So they don't mince words. This is like they violated the most basic requirements of the law, rudimentary demands of fair procedure, and they didn't just violate the law. It was an injustice to the victim.
Some of you have asked, I've seen this question come up a couple times. Why does it matter that the victim has to be there? It's not like they're presenting evidence. They're not the investigatory body. They're not the prosecuting body. So what does it matter? The law matters. And so you're right. Victims didn't have rights at some point, but you and I, not exactly you and I, but the politic decided that victims' rights matters, and people petitioned their legislature so that we have federal Victims' Rights Protection Acts as well as state-by-state victim protection acts. And in this instance, the legislature had passed such a provision to protect victims' rights, even if it's just a notice right. They may not be able to change the outcome, and that's fine. We're not even commenting on that, but that's the whole point. We don't know what was said. The victim doesn't know what's said. Nobody knows what was said because it was not recorded. It was in camera, meaning it was not before the public, and it was not written down in a transcript, as all court proceedings typically are. And with that said, the law is the law. If you don't like the law, you can go overturn the law, but there is a process in which that is done, and the law can't be vacated by one district court judge who just decides that this law doesn't apply in this case.
And in fact, the court, echoing Alice, maybe you should be on the court, says the state of Maryland has given constitutional and statutory rights to crime victims, and the state's attorney should not be allowed to thwart those rights in the way that happened in this case. The no pros entered under the circumstances of this case violated Mr. Lee's right to be treated with dignity and respect. And I got to say, look, I don't want to harp on this thing, but I just think you are paying lip service to victims if you have a lot of really great virtue signaling tweets about respecting victims, and then you're like, but in this case, the fact that they just totally screwed this guy over is fine. Like, and I think
go read your
they
states. Yeah, go read the federal victims. VPRA. I'm completely butchering it. Sleep deprivation is real. The Victims Protection something Act.
Victims' Rights Protection Act. VRPA.
There we go. VRPA. You go read the Federal Victims Protection Act. Go read your state ones. They all pretty much mirror each other. And it's basically notice, right? Put yourself in the victim's family's shoes that, your sister, your loved one, whoever has been brutally murdered. You may not be able to change the outcome because you're not the charging body. You're not the police investigating, but you have a right to know if this person was previously going to spend the rest of their life without any parole, to be in prison, and then the next day they're going to be out. Don't you think, if it were you, it would be helpful to reorient your life? Are you fearful for your life? Imagine that this was someone who's very close to you, like a family member who murdered your other family member. Does this mean that there's harm coming to you and your family? Are you going to be surprised when they appear on a Netflix special, free and about, teaching at Georgetown, chilling out on the beach, talking about how wrong they were? This is all, we've decided that victims do have some right here because they don't have a right otherwise, right? Victims don't have a right don't have a right before we implemented these protections to testify in a trial, for example, until we passed these laws.
And I just want to point out what he asked for. 7 days. That's all he asked for. He asked the court for 7 days to come to the hearing, to figure out what exactly the state was saying, understand their arguments, and be able to formulate some sort of, possible agreement with it. I mean, who knows, right? If he'd been given 7 days, maybe he looks at the evidence and he changes his mind. That's all he asked for. That's all we're talking about here. If the state's attorney and the court had given him 7 days, this is probably completely over. But they couldn't even do that. They couldn't even give him 7 days. So on the first point, he wins. We're not going to worry about standing or moving forward. He then has some claims about how his rights were violated. I mean, because that's just the first question. Can he even make the argument? Then it's how are his rights violated? He says, the first way is you had this secret in-camera hearing. And the court looks at the law and they says, well, the law does not say that you can attend the hearing. But then at the very end of that discussion, and one of those sort of backhanded things that we've talked about, they say, we note, however, that if there is an in-chambers conference, the judge should put on the record what was discussed in chambers. Just like one sentence of what are you doing that you did not even record that?
Not even one sentence.
Yeah, it's like you did nothing.
And so, in practice, court moves really quickly. Sometimes you have these sidebars, something happens where you do have in-camera discussions. If anything of substance happens, because you don't always know what's going to happen. We have this a lot when we have pro se litigants, pro se defendants in particular. They ask to talk to the judge and the judge really has no idea what they're going to say. And it turns out what they're talking about is substantive. What typically happens and what is proper procedure is you come back out into the courtroom, you make sure that the court reporter is ready to start dictating. And the judge says, now we're back on the record. I'd like to talk about what just happened in my chambers. So-and-so and so-and-so came back there and we began to talk about so-and-so. This is required by the law to be on the record. So I'd like to repeat that conversation here, so that everything is on paper. I mean, that's happened to me several times, especially in the instances where trial may be fast moving, a particular hearing may be fast moving. Brett's talked about where you're surprised by new evidence coming on during a substantive hearing. And then, everyone's kind of in a flurry trying to figure out what's going on. And some discussions are not on the record. The court is supposed to have order within their court and make sure the record is clear. And they call out those conversations that have not been properly transcribed and make sure they are then on the record. You can reference that a conversation happened. You can cure things so easily in the court. And the appellate court here is just calling them out. You never even put one sentence, not even something as simple as the evidence was overwhelming and to not let him go today would be injustice. They didn't even say that. I mean, I don't think that's enough, but yeah.
And just to reiterate continuously, Alice and her deep understanding of the law, when the court says this, they cite a case that says, they cite the case, and then in a parentheses, they say, at the conclusion of a chambers conference, the court should announce on the record, at the very minimum, what was agreed to during the discussion. So yes, if they had just done that, if she had just come out and said, hey, we talked about this, this, and this, we reached this decision, let that be on the record so future appellate courts can consider it, that would have been enough. Didn't do it.
If you can't tell, the law is not meant to be a gotcha sort of thing. You may have heard a term, spirit of the law. Spirit of the law basically is like, we are governed by man, and we can only do so well with our words and how we craft them to create these laws that are not a perfect fit for every situation. But what we attempt to do is to fulfill the spirit of the law. So the appellate court is saying, we're not doing a gotcha situation that you forgot to bring the court reporter to your in-camera conference back in chambers. You could have easily put on the record what had happened, because the spirit of the law is transparency. And what we lack here is utter lack of transparency. Sure, if you had made a mistake, this is not gotcha. Come out and solve it. Solve the problem. What is the law trying to get at? The spirit of the law is transparency for the public, for everyone to know what is happening. You lack that very core spirit of the law, and therefore you're reversed. And I think that's incredibly important here, because a lot of people try to make the law out, especially when you're talking about procedure, to be you don't know the rules of the game and you do a misstep, and the whole system is stacked against you, especially if you're a defendant, because who knows the rules better than the judge and the prosecution. That's not what's going on here at all. Really, the appellate court is giving every leniency to the court below, and they're saying, you've done nothing. We can't point to a single thing to hang your decision on that we could defend it. And so we are required by the law to reverse this.
And people have asked, why would this judge do this? Why wasn't the judge more thoughtful? Well, look, you're getting into conspiracy theories and what we know and we don't know. But it's pretty evident, and there's some read between the lines stuff in here that I think the appeals court agrees with this. This was all a fait accompli, right? The prosecutors had decided they were going to let Adnan Syed out for whatever reason, whether because justice demanded it or because Marilyn Mosby needed good press. You can decide what you think is there. Obviously, the defense agreed with that because that's their job, and they want Adnan Syed out, and they believe he's innocent, and they want him to be completely vindicated. The judge very clearly had made up her mind. I keep saying her. If I'm misgendering her, excuse me, but had made up her mind that she was going to release Adnan as well. And the court points out in their appeals, they note a couple things that are interesting. So they had this whole hearing where it's supposed to be, I think they put evidentiary hearing in quotation marks at one point because they say something like the supposed evidentiary hearing. But they note that at one point, the judge actually releases the press who's in the hearing room and holds everyone else in the room because she knows there's a press conference afterwards and she wants the press to have plenty of time to get in position for the press conference. Adnan he had all his clothes. He was ready to go. Like when they walked in that day, this was done. There was no actual substantive hearing that was going to happen here. And so I don't know why the judge did some of the things that she did, but I think possibly it's that she really didn't want what they talked about off the record to be on the record. And I mean, I think when you read between the lines of this, it kind of feels that way. Okay.
I love words, Brett. That's probably why I picked the right profession. But the scare quotes around evidentiary hearing, I actually laughed out loud when I read it because it was like a literary booyah. But that's actually right, because we don't know that it's an evidentiary hearing. Evidentiary hearing requires following the rules of evidence to properly admit evidence.
Now, so then we move on to the next issue. So, sorry, Mr. Lee, yeah, this was messed up, but you don't have a right to complain about that, essentially. Then they say, did he get notice? Everyone agrees he got notice. He was told it was going to happen. It was not great notice, but as they point out, all the law requires is notice. They also point out that even though multiple people argued, and this goes back to our statutory interpretation episode, if you didn't listen to that, we talked about legislative history. So the court in this decision does a lot of legislative history research because Younglee argued, I don't only get to be there, I get to participate. I get to speak on behalf of my sister in a real substantive way. And the court's like, look, we agree. You should totally be able to do that. And it seems like everybody else in the world thinks that. But they point out that while this legislation was being debated, multiple people said, hey, we need to change the law because it just says attend the hearing. It really needs to say attend and take part in, or attend and speak at, or something. And the legislature never changed the wording. And since they didn't change the wording, the court took that to mean, sorry, you could interpret it that way, but we're going to take that as evidence that that's not what the legislature intended, and therefore we're not going to interpret it that way. So they also shut him down on that was a shortcoming. So really, it comes down to this question of whether or not he was given sort of fair opportunity to attend the hearing. And they note that the record reflects the prosecutor, Ms. Feldman, sent an email to Mr. Lee on Friday afternoon, September 16th, 2022, right after the chamber's hearing, which the parties represent is when the Monday, September 19th hearing date was set. So in the afternoon on Friday, she sends an email to young Lee and says, hey, hearing on Monday morning, be there if you can. We're gonna let Adnan Syed out. That is essentially what they say, right? And so the question is, did that give him adequate opportunity to attend the hearing? And one of the arguments that the defense makes, and it's interesting because you have basically the state of Maryland is on young Lee's side. So they're saying law was totally violated. You need to vacate this. Obviously, you have young Lee. Then you have the state prosecutor's office who's on Adnan Syed's side. But it's really Adnan Syed and his lawyers who are making the arguments. So he's the one arguing, no, the law was followed. You should just drop this, right? So this is the point where they talk about what actually happened that day. So counsel for Mr. Lee advised the court at the beginning of the hearing that Mr. Lee wanted to be there in person, and counsel requested a postponement of 7 days so that Mr. Lee could arrange to take leave from work and fly from California to be present in the courtroom in the same way that the court and the parties were present. Everybody else is there except him. The court denied the requested postponement and proceeded without Mr. Lee in the courtroom. He was permitted to give a statement on Zoom with only 30 minutes allowed for him to go home from work, to get on Zoom and prepare what he wanted to say. So they deny the 7 days, and they basically say, go out. We're going to start this. Go out, call your client, tell him he's got 30 minutes to get on Zoom and give whatever statement he wants to give. That's his participation that we're going to allow.
And really quick, guys, again, I want to underscore how the law is not meant to be a gotcha. I see a couple questions here like, oh, well, what if there were no victims' families here? I haven't studied specifically Maryland's victims' rights statute, but typically there's some notice requirement. So we do this all the time in our jobs. We think there are victims, maybe they're unidentified, or we don't know who the extended families are, or who is like next of kin. You do lots of different ways of notice. You can publish online at the prosecutor's website. You can publish in the newspapers. You can literally just say, here is notice, in a press conference, whoever wants to say something, here's the victims' rights hotline, call and we'll get you set up. Make sure that you have a right to be here. The whole point here is they didn't have to go hunt for a victim or next of kin to Heyman Lee. They had someone petitioning the court for a very reasonable 7 days just to have his rights be met under the law. And that's what's here. So don't get hung up on these kind of, and I don't think you guys are necessarily getting hung up. These are very good questions. And they're questions that I see, pinging out there as people are trying to say that, this is a gotcha sort of thing. This is not a gotcha sort of thing. Read the opinion. And remember, the facts at issue here are what matter. Young Lee here has petitioned. They don't have to go hunting for him. He is literally standing in front of them, with 30 minutes to prepare on Zoom. And they deny him the basic rights that the law affords him.
And so one thing the opinion does, which once again, they didn't have to do, but they did, is they printed the entirety of Lee's statement to the court. So I want to read it to you. So this is what he said after, managing to get on the Zoom and take part. I apologize. There were some issues with Zoom. I personally wanted to be there in person, but Your Honor, I've been living with this for 20 plus years, and every day when I think it's over, when I look and think it's over or it's ended, it's over, it always comes back. And it's not just me killing me and killing my mother, and it's really tough to just go through this again and again and again. I believe in the justice system, the court, the state, and I believe they did a fine job of prosecuting Mr. Syed. And I believe the judge did make the right decision. But just going through it again, it's a living nightmare over and over again. It's tough. And I'm not, like I said before, I trust the court system and I just trust in the justice system. And I am not against, I was kind of blindsided. I always thought the state was on my side, but I don't know where. I hear that there's a motion to vacate judgment. And though honestly, I feel honestly betrayed. I keep thinking to myself, why is the state doing this? And I'm not against an investigation or anything of that sort that Mrs. Feldman is doing. I'm not against it at all. But the motion just to vacate judgment, it's really tough for me to swallow, especially I'm not an expert in legal matters, in law or anything like that, but I ask you just to make a right decision that you see. But just this motion, I feel that it's unfair, especially for my family, just to live through it all and knowing that there's somebody out there just free of killing my sister. It's tough. And I just wanted to say this in person, but I didn't know I had the opportunity, and it's tough. Yeah, it's tough. It's tough. This is not a podcast for me. It's just real life, never ending after 20 plus years. Just on the thought that I just want the judge to know the stuff that we're going through, our family, it's killing us. And I ask that you make the right decision. That's all, Your Honor. So that was his statement.
Guys, how can you listen to that and question why victims' rights legislation is in effect? I mean, that was so raw. Kudos to the appellate court for printing that entire part, because I think we all forget that these are real people's lives at issue here. Heyman Lee isn't here to say the effect this had on her, the horrors that she went through. And listen to what he said. He is not talking about guilt or innocence. He wants to know who killed his sister. But there is no process here when they have been dragged through trials and appeals for 20 plus years. And then the state on its own volition can do something with essentially no sunshine into what they're doing, no testing of what they're doing, and testing in terms of an adversarial process. That's the whole point of the judicial system, is to have an adversarial process. And that's what's lacking here. He doesn't know the legal terms, nor should he. He's not a lawyer. But what he's saying is the very spirit of that. He's saying, this seems wrong. I can't put to words what it is. I don't know the fancy legal terms, the Latin terms that describe what I'm feeling, because he doesn't need to. Right? What he's saying is exactly what the spirit of the law, what we were talking about before, is. You don't have to be some learned legal scholar to know these things. I think he said it beautifully, and it was heartbreaking. And, we've talked about finality and the need for it. And the fact that finality can exist in the criminal justice system leads to justice. It is so important, not just for the victims, for the defendant, for the state. Now, I'm not talking about the prosecution. I'm talking about the citizens who live within that state, who vote for the laws, who vote for their prosecutors, who vote for their government. Finality is so important because these are tax dollars at work, and the justice system is already overwhelmed with these types of cases. If we are on this constant mouse wheel, what is it called? Hamster wheel. If you're constantly on this hamster wheel on one case over and over, how is that lack of finality justice for any of the parties involved? It's simply not. And he said it beautifully. It was unfiltered. And that was the absolute essence of what these victims' rights laws are getting at.
And so Syed is in the unenviable position of arguing, Zoom was good enough. That doesn't seem great, but he has the right to appear. He appeared via Zoom. Therefore, we're all good, right? That's the argument they have to make. And they sort of argue like, look, during COVID-19, we did Zoom all the time. We did Zoom for all these hearings. This is a loser argument. And I know they had to make it, but the reason it's a loser argument is what every judge would know is before COVID, and I wrote a memo for this in our office, there was a real question whether or not you could legally have Zoom hearings. And it was a big problem because all of a sudden COVID happens, the court shut down. We have all these timing requirements. You got to do things within 15 days or 30 days or 7 days or whatever. And it's like, well, the courts aren't going to be open for months. What do we do? Can we hold these hearings by Zoom? And there were a lot of hearings. It was just obvious. No, there were laws. There was case law that said appearing by video is not the same as being in the courtroom for all sorts of reasons. And it wasn't, in the federal system at least, the CARES Act was passed by Congress, and it included specific provisions that allowed Zoom hearings to happen, but then only if the presiding judge made a finding that the interest of justice required you to have that Zoom hearing as opposed to opposing it. And so, we would be with defense counsel joining together, making an argument of, hey, we know this isn't preferable, but we got to do this by Zoom. So the idea that Zoom was good enough was already weak, but the bigger problem they had, nobody else was there by Zoom. And so the court points out that the law, CP 11-102A, provides that the victim has the right to attend any proceeding in which the right to appear has been granted to a defendant. And then they point out Mr. Syed was allowed to attend in person, but Mr. Lee was required to attend via Zoom. And that was a violation of the plain language of the law, and was one of the reasons that they were like, look, this is not, no, you can't do it this way. They go on to say, or go ahead, Alice.
Oh, no, I was just saying, I might have to cut out soon. This is an 84, 85 page opinion. My sweet baby, who is not here with me anymore, for those of you who are afraid that I wasn't letting my baby breathe, is crying for mom. So I might
just
have to
go get her and bring her back.
No, she's very loud. She's like her mother. She's very loud.
Well, you kind of pop in and pop out as you need to. Like we don't.
Okay.
We want you to be here, but if you need to go, if you need to have, everybody here is happy to have the baby, even if the baby's making noise.
She's very loud. I love you guys, but she's loud.
I can hear her.
I can hear her too.
Well, you do what you got to do. I will try and hold forth as best I can.
You continue.
By myself. But you can, like I said, you can come in and out.
Thank you.
I'm just going to pretend that Alice is still here because it's better when she's there. So anyways, so they kind of continue this. They cite to some civil cases, and they say a court is not required to require a victim who has a right to attend a vacated proceeding to attend the proceeding remotely in the situation where the defendant and other participants are permitted to attend in person. Nevertheless, that is what the court did here in what indisputably was or should have been an evidentiary hearing. And so that's where they sort of get that attack. It's not the scare quotes, it's the or should have been in parentheses, where they point out this was supposed to be an actual hearing, but in fact, it wasn't. So you have the situation where there's no opportunity for him to come and attend in person. Everybody else is attending in person. And the court essentially says, look, that's a violation of his rights. You violated his rights, and we're going to have to do this over again. And because you violated his rights, everything you did up till this point has been sort of a nullity. And so you're going to have to do it again. And I'll read you the conclusion, because the conclusion sums it all up. And the conclusion leads into the second question, which is what happens next? Is this a technicality? Is it something where, whatever, we'll just go do it again, and the exact same thing will happen, but this time Young Lee will be able to be there, and that way justice will be served? And let me just say, even if that were it, it's enough. It's enough reason to do it, because it matters. It matters that people's rights are vindicated, even if it means we have to go have the hearing again. That's how important it is. And even if at the end of the day, we have to have a good hearing that follows the law and allows victims to speak, that's enough. And the fact that it may seem like a technicality or, something that's like whatever, it's just a do-over, even if that's true, it's important and it needs to happen. And I'm glad it's going to happen.
And we do that all the time. Sorry, I'm like off camera, but we do that all the time for defendants' rights, right? We do that all the time. And that's because the Constitution affords it, the law affords it. And that is the same here. Imagine if we were to say a technicality was to be heard. Where do you draw the line? Essentially, there'd be no force of the law at all. When one judge gets to decide which lines of the statute you get to enforce and which ones you can just kind of, it's a technicality, that's a really scary place to live. And I don't want to be in that sort of a justice system at all, because again, process matters. Even if the outcome is the same, process matters. Look at all the habeas proceedings that we had for death penalty cases. A lot of those cases end up the same way, where ultimately the death penalty is not vacated. But the countless appeals that are afforded to them are afforded to them because the law allows it and they are important. And every court that hears each of those appeals considers the briefings in front of them. They don't just say, oh, this is just a rubber stamp. Never. They shouldn't do that, in fact. And so, I can't emphasize enough that process isn't just process here. It's not just a technicality. It is the process that leads to the justice and affords the right in this situation.
Right. And I've had that situation where a judge has entered an illegal sentence. So imagine you got convicted of 10 different counts of various different things, and each count has a maximum sentence of 20 years. But the judge looks at sort of sentencing guidelines and everything else and thinks a 25-year sentence is appropriate. There's a way to do that. You sentence them to 20 years on one count, 5 years on count 2 to run consecutively, and then everything else runs concurrently. You have a 25-year sentence, right? Well, I've had a situation in which the judge just gave them a 25-year sentence. So he gave them 25 years on counts that had a max of 20. Well, we had to go do that again. We had to come back. We had to have the hearing again, had to have the defendant there. The judge had to go through the sentence again, explain why he was doing what he did, and impose the exact same sentence, but he did it in a legal way. And Alice is right. This happens a lot. It happens all the time, as a matter of fact. But it's important to hold people to those standards and make sure that the law is followed, because when you let it slip in one area, it's going to keep slipping, and it's going to slip in a way that violates more and more people's rights, maybe in ways that are more substantive. Now, look, I think this was a substantive violation. The fact that this guy, after all this time, it's just, why? And we talked about this in our first episode, and people got mad at us because they were like, if Adnan's innocent, he should be released immediately. And I totally get that. I totally get that argument. But the fact of the matter is, for the last 22 years, he's been in prison for murder, a murder conviction, a jury handed down, and that multiple courts have affirmed at the end of the day. There was, one time it went all the way to the Supreme Court of Maryland, but they ended up affirming it. And so I'm sorry, but when you're in that situation, sometimes you have to wait 7 more days to have your conviction completely vacated because there's other people than you who matter. And I think that it was wrong, and it was good that it was handled. And here's what the court concludes, and this is going to lead into what's next, because listen to what the court says. Because the court violated Mr. Lee's right to notice of and his right to attend the hearing on the state's motion to vacate in violation of CP section 8-301.1d, we have the power and obligation to remedy that injury. Therefore, we vacate the circuit court's order vacating Mr. Syed's convictions and sentence, which results in the reinstatement of the original conviction and sentence. We remand for a new, legally compliant, transparent hearing on the motion to vacate, where Mr. Lee is given notice of the hearing that is sufficient to allow him to attend in person, evidence supporting the motion to vacate is presented, and the court states its reasons in support of its decision. So, all this was about 7 days, right? This was all about just making sure Mr. Lee can be there, so when we just do it over again, he's there for it. That's not what the court says. The court says you're going to have a new hearing, and this time you're going to do it right. And when they say you're going to do it right, they don't limit it to Mr. Lee's going to be there. They include there's going to be evidence supporting the motion, and the court is going to state its reasons in support of its decision. And that brings us back to everything else they've said. I talked about this, how there's like little things in this opinion that are important. The most likely outcome here is that this will go back to the court. They'll have a day-long hearing. The state's attorney will support the original position. Adnan Syed's conviction will be vacated, and the convictions against him will be dismissed, or the charges against him will be dismissed. I think the most likely outcome is we'll be back in the exact same place we would have been anyway. However, there's a couple things to note here. Number one, the state's attorney is different. Marilyn Mosby is off dealing with her own issues. She is no longer the state's attorney. The new state's attorney has said before that, and someone can correct me if I'm wrong, that if Syed's conviction were ever vacated, he would not appeal it. That's a little different than he would seek to vacate it. We'll have to see what his position is on it, but he's a different person. So it's not the same person as before. Moreover, the attorney who wrote the motion, the other attorney whose name is mentioned a couple times in this opinion, it escapes me right now, she's no longer there either. So neither one of the main attorneys, the drivers in the state's attorney's office who push this, are there anymore. We don't know the position of the people who are still there. And we don't know the position of the new state's attorney. It's possible they will take a different position. I don't know for sure. It's possible the state's attorney will feel an obligation just to do what his predecessor did, which a lot of times, your prior person makes a promise, I'm going to keep the promise. So we don't know, but assume for a second that they do go forward with it. There are things in this opinion that are interesting. Like I said, they could have limited this to just the question of attendance, but they don't do that. And if you read it, and I read it, read the footnotes. Because the footnotes are where all of the sudden they start to say things that are sending sort of a very clear signal. One of the first footnotes just goes at something that I have heard 1,000 times, which is, what are we talking about? Adnan's he's innocent. We know that because of the DNA. There's DNA that came back, right? Well, they drop a footnote about the DNA just for really no reason, right? And they say, we note that despite these statements and the assertion that the state is not asserting at this time, this is a little long, but bear with me. We note that despite these statements and the assertion that the state is not asserting at this time that Mr. Syed is innocent, less than 1 week later, on September 20th, 2022, then Baltimore City State's Attorney Marilyn Mosby stated that she intended to certify that Mr. Syed was innocent unless his DNA was found on items submitted for forensic testing. Mrs. Mosby did not explain why the absence of Mr. Syed's DNA would exonerate him. They then quote to a Supreme Court of Maryland opinion with a parenthetical that says, where there was no evidence that the perpetrator came into contact with the tested items, the absence of the defendant's DNA would not tend to establish that he was not the perpetrator of the crime. If you followed this, you know that after this happened, they got some DNA test results back that were basically like, we tested her shoes and there's none of Adnan's DNA, but there's random DNA, and we don't know who that is. So maybe that's the killer, right? And that was like sort of their big bombshell. And people have taken that to mean, well, Adnan Syed, he's been exonerated by the DNA, but it's touch DNA and it's on her shoes, which is basically the weakest possible argument you could make. It is interesting that the appeals court, for no reason, because this was not before them, just takes a shot at this and like decides to drop a footnote and say, sorry.
I love that. I love that, by the way.
Yeah.
I feel like, footnotes are one of my favorite things because correctly used, they can be so powerful. It's in a footnote, by the way, guys, because this is not before the appellate court. It is nothing that they had to comment on, but they are not living under a rock. They know what's being said about this case. And remember, these opinions are meant to be read by lay people. They're meant to be understood by lay people, not just, legal scholars. And right here, they're talking directly to kind of armchair detectives, podcasters, Netflix documentarians. They're saying like, guys, use your own brain here. This is a false argument. Don't fall for it. It's not before us, but we kind of need to just educate the public a little bit here. And I respect that.
And it reminds me so much of the Ellen Greenberg case. We talked about this. The court in the Ellen Greenberg case, they had like very dry technical issues before them, but they took the time to lay out the factual problems they had with the suicide story. And they did that because they wanted the lower court and the politicians, the AG's office and everybody else, the DAs, to hear it from them. Like, hey, we know you've taken this position, but think about this. And this is a message to just people in the public. It's also a message to the state's attorney's office. Like, hey, new state's attorney, we know that the lady who used to be there said these things. These things don't make sense. And there's more of it. And the next footnote is talking about the Brady violations. And you've heard about this, that there are Brady violations because there's evidence that there might have been a couple other suspects who did it. They drop a footnote. CP section 8301.1b2 provides that a motion to vacate must, quote, state in detail the grounds on which the motion is based. But the state's motion did not identify the two alternate suspects or explain why the state believed those suspects committed the murder without Mr. Syed, which the without Mr. Syed is also an interesting thing for those of you who follow the case. The note indicating that one of the suspects had motive to kill Hay is not part of the record on appeal. And in the state's October 25th, 2022 response, the Office of the Attorney General stated that there is other information in the note that was relevant but not cited in the motion to vacate. And as some of you who followed this know, there's a lot of argument now that in reality, the note that they're talking about which says something along the lines of the person is going to kill Hay, the prosecution may have actually believed that it was Adnan Syed who wrote it. So the defense position and sort of the state's position now is that this pointed to another person who was close to Adnan Syed who may have been involved in the murder. The court, by dropping this footnote, is saying, hey, and we talked about this in our episode, that they talk about this Brady violation, but they don't prove it, and they don't give you any information about it, and they don't provide any reason to know for certain that there is a Brady violation. And the court is saying they didn't do what they need to do, lower court. So when you hear this again, think about this, is what they're saying.
What a great point, because we hear these terms thrown around the media all the time. Brady violation. You can't just like assert Brady violation. This reminds me of, what is the show? Oh, The Office, when Michael Scott says, I declare bankruptcy. And he thinks by stating those words, he is declaring bankruptcy as a financial, protection. You can't just say Brady violation and all of a sudden there's a Brady violation. Go listen to our other episodes, because a Brady violation actually has legal standards, and you have to meet those legal standards to find there to be a Brady violation. And so I love that here. And again, it's pointing out, you heard little baby trying to chime in here. And I love that here, because it's educating, again, the public about very important things. You don't get to just declare bankruptcy. There are legal processes and showings you have to make and filings you have to make in order to be found to be bankrupt. Same here. You don't just declare Brady violation and there we go. That's a Brady violation. It's actually a legal finding, and there has to be a showing made to meet the elements to show that there has been a Brady violation. So the assertion that there is a Brady violation is not in and of itself enough, and does not in and of itself make there a Brady violation here.
But they're not done. They're not done. They drop another footnote on the Brady violation. They say, we note that although CP section 8301.1F2 requires the court to state the reasons for its ruling, the court did not explain its reasons for finding a Brady violation. See State versus Grafton. A Brady violation requires proof that 1, the prosecutor suppressed or withheld evidence, 2, the evidence was favorable to the accused, and 3, the evidence was material. It did not explain how or if it found that the evidence was suppressed, despite the lack of affirmative evidence that the information had not been disclosed, and the statement in the motion to vacate that, quote, if this information was indeed provided to defense, the failure to utilize it would be ineffective assistance of counsel, which we pointed out how weird that statement was. The court's picking up on that too. The court also did not explain how the notes met the Brady materiality standard. Additionally, the court found that the state discovered new evidence that created a substantial likelihood of a different result, but it did not identify what evidence was newly discovered or why it created the possibility of a different result. Once again, completely unnecessary to the analysis in this opinion, but obviously directed at the court that they know they're sending this case back to. They are sending a very clear message to the court. The next time you have this hearing, you better address all this stuff, because if you don't, the next appeal is not going to be about, did he get 7 days? The next appeal is going to be about the substance of what you're claiming. And we're telling you that so far you haven't told us enough. I mean, in a lot of ways, they're doing the court a favor. In a lot of ways, they're doing Adnan Syed a favor. You need to address this, is what they're saying. If you're going to do this, explain why you're doing it.
And Brett, by the way, that's a great point when you're saying that the court, I can't, you guys know how it is with a newborn. I can't speak properly right now. Everything the court is saying in its opinion to talk to the lower court, they do so because they're not having background conversations, in-camera conversations with the other judge. Everything is on paper for the rest of us to read. And that's beautiful here, because they are dropping notes on like, hey, this is how we're leaning. This will come up before us again. It could come up before us. This is how we're thinking. Judicial efficiencies here matter. And we're telling you something, but we're not telling you through some back channel. We're telling you in plain sight, on a published document that the whole world can see. And that just goes to the whole point we've been talking about throughout this opinion, that transparency matters. Courts talk to each other all the time. And that's what this court is doing here. But note how they're doing it. They're doing it for the world to see, and not some, behind a veil sort of situation.
So in their discussion, as they begin their discussion of the issue, they say, the scope of our review in this appeal, however, is limited to whether the court denied Mr. Lee rights to which he was entitled as the victim's representative, which is what we've been talking about up to this point. But that's not the first thing they say in the discussion. The first thing they say is, in his briefs filed in this court, Mr. Lee lists multiple concerns about the vacater proceedings. Initially, he contends that the state and the circuit court violated his rights to reasonable notice, to appear, and to be heard. He further asserts that the court held an improper, clandestine, in-camera pre-hearing, which neither he nor the public knew occurred. He argues that the on-the-record vacater hearing was a farce, where no evidence was produced and there was a predetermined outcome decided in the closed chambers pre-hearing. Mr. Lee challenges the validity of the state's assertion that there was a Brady violation, and he asserts that the court did not properly issue findings explaining how there was such a violation. Mr. Lee argues that the circuit court conducted neither a full nor transparent review of a long since discounted evidence. We share many of Mr. Lee's concerns about how the proceeding was conducted. Once again, the court going out of its way to say to the lower court, the next time you do this, you have a lot of work to do. And there are a lot of things that you did that are not before us that we are not happy with.
And guys, this matters because they are the reviewing court. There's not like gamesmanship where you can, appeal up to a different court here. So this is like, imagine if, when your teacher knows there's going to be a pop quiz, and right before the pop quiz, they're like, guys, we've really focused on this chapter and these facts that we've been learning about. So really focus on them. I'm telling you to look on page 52 before I tell you to close your books and we're going to have a pop quiz. That's what they're doing here. They're not trying to hide the ball. They're listing their concerns, and they should, because they're going to be the reviewing body if there's another appeal in this case. And again, it's proper. We see this happening all the time. This just happens to be a very, public case, and so a lot of people are reading it. But everything this court is doing, that's why there's an 85-page opinion, is proper, and what happens all the time when opinions are talking to each other.
And the court drops another footnote because it's not done. So it's talking about sort of what the purpose of these hearings are and when you should vacate a conviction. And they go through the committee notes and the legislative history and everything else about this. And they drop a footnote and they basically talk about the legislative history. And we talked about this in our opinion, or in our last episode. The legislative history indicates the statute was enacted, at least in part, in response to criminal activity by members of the Baltimore Police Department's Gun Trace Task Force. The legislative history also reflects an intent to allow the state to move to vacate crimes based on acts that are no longer a crime, such as use or possession of less than 10 grams of marijuana. And here's the kicker. And here's the thing that if I were Adnan's lawyers would concern me. The history suggests that the statute was intended to be used when there was no dispute that the conviction should be reversed, although its ultimate language does not include any such limitation. So the appeals court and this statute has had very little. We talked about this when we did our opinion, I keep saying our opinion, when we did our episode, that there's not a lot of courts who've interpreted the statute. And what you have in a footnote is the appellate court essentially saying to the lower court, hey, we've told you all the things you need to do. The standard you need to apply is a high one. It's not, sounds good to me. It's essentially, is there no dispute that there's an injustice here? Is there no dispute that the person is innocent and should have their conviction vacated? That is a really high bar to meet and a really difficult bar to meet. And it makes you wonder, we don't know, and people have asked if it's going back to the same judge. I think it is, but I'm not sure. I don't know that for certain. You would think if it goes back to the same judge is going to want to reach the same conclusion. But that judge, look, judges don't like to be reversed. And that judge will have read this opinion. And judges can read between the lines as well as we can. And that judge is going to read this stuff, and we're going to see whether or not they do it. Somebody asked me an over-under on number of times that Adnan Syed's conviction would be reversed and that would be reversed. If this just goes back down to that court, and that court rubber stamps this again, and does the exact same thing they did before, and it goes to the appellate court, they will reverse it again. I have no doubt in my mind about that.
And there are other things the appellate court can do. Ultimately, there are mandamuses. If a lower court judge is just violating what the appellate court has mandated them to do, we haven't gotten there yet because these are all advisory notes that they're given. So they haven't had a holding with respect to the evidentiary findings. But if it were a rubber stamp and they just completely disregard legal standards, eventually the appellate court can do certain things. And we've seen this in certain cases. It's very rare because, judges are all their own little fiefdoms, but ultimately the appellate court could find that there is like an inability to follow the law for a court and basically reassign the case. That happens very rarely. There's high standards to meet there. I'm not saying it'll happen in this case, but it will not be an infinite loop of like a district court giving the appellate court the middle finger. There are steps that the appellate court can make in order to make sure that the law is followed and no one is above them, not even another judge.
So a few things about, and that's really all I have on the opinion. I don't know if Alice has more, but a few things on what happens next. So some people ask, can Adnan appeal? He can seek cert from the Maryland Supreme Court. Unless they do it just because this is a famous case, there's no reason for them to take it. This is an interpretation of a statute by the court. Oh, by the way, the dissent, his reasoning was essentially, he got to appear by Zoom. We've done Zoom during COVID. That's fine. He basically kind of bought that argument, even though I think it's a loser argument. I mean, he makes a couple points that he didn't really have a right to participate anyway. So if he's just watching it, why is that so bad? He bought that. But it wasn't like he's pounding the table about injustice. He just bought that argument. You could appeal it to Supreme Court. This is not the kind of issue that would normally rise to Supreme Court consideration. It is possible that Maryland has automatic cert. I just don't know that. I haven't had enough time to really look at that. Some Supreme Courts do have that, though that is vanishingly rare now that Supreme Courts don't control their own docket because Supreme Courts don't want to take every case. Most likely, if they have an option to decline it, they'll decline it because all you got to do is go back to the district court and do it again. Adnan will not be in jail. He will not be sent back to prison. The courts, they stayed their own order for 60 days to sort of let the parties figure out what's going to happen. So I said earlier that Adnan is now a convicted murderer. Technically, he's not. He'll be convicted murder in 60 days when the opinion sort of becomes official. At that point, if it got to that point and nothing had happened, which I think is unlikely, the most likely thing is the state or the court would grant him some sort of bond. I mean, the chances of him just going back to prison to wait this out, I think, is pretty slim. So I would expect that the parties will try and figure out what to do next. If they seek cert, they'll seek an extended stay until the Supreme Court decides on that. They would probably get that. Then at some point, if the Supreme Court of Maryland doesn't overturn this, it'll go back to the trial court and they'll have to do the hearing again. And we'll just have to see what happens at that point.
I have nothing else to add, Brett.
And look, I mean, like I said, we'll just have to see what the state's attorney wants to do. A really interesting thing about this, just to go to this whole, you've seen a lot on Twitter. This is a technicality. They're just going to do the same thing again. I think you see why that's probably not true. The other thing, the wild card in all this, is the AG's office. When this happened initially, it happened so fast that everyone from Young Lee on down was caught off guard by it. The AG's office, they released a very sort of terse statement that basically said, look, number one, there's no Brady violation here. And number two, you've been looking at this for a year and nobody ever told us. And then you had Marilyn Mosby and the Attorney General of Maryland fighting each other. And Marilyn Mosby basically accusing the Attorney General of Maryland of trying to keep innocent people in prison. This is rough, right? That's not going to happen this time. Everybody's ready. So if the Attorney General's office wants to take this, if they want to appeal this time it's not going to be a surprise. They have exactly what they need. If they want to appeal it, they can. And that is an added element that's a complete wild card. They supported Young Lee in this effort, but they did not appeal the substance of this issue. Will they appeal the substance the second time? Hard to say, but it's going to be interesting to watch just from sort of a procedural, technical perspective.
Absolutely.
Well, Alice, do you have any more baby pictures you want to show us?
No, but
So somebody asked, has this ever happened? Are you talking about, has something like this ever happened? Jeffrey McDonald was free for a decade after his initial thing, and then was tried and convicted. He had moved to California, become a surgeon, bought a bachelor pad on the ocean, and was driving around a convertible for 10 years. So yeah, it's happened before that something like this has happened. And in fact, I think after he was convicted, he then got his conviction overturned on speedy trial grounds, went back to California and his convertible. Then the Supreme Court reversed that acquittal, and he went back to prison. So the answer is yes.
Here's a plug for you to listen to those episodes, because I remember we went through them in our series on Jeffrey McDonald, and it was so aggravating. I mean, that felt so unjust. But ultimately, justice.
And no, Paige, he was acquitted by the JAG. Then 10 years later, he was convicted by the DOJ. He then challenged that conviction in the Fourth Circuit as a violation of speedy trial rights, had his conviction overturned by the Fourth Circuit. Then the Supreme Court of the United States took cert, and in, I think, a 6-3 decision, reversed the Fourth Circuit's opinion. So, yeah. Like,
that procedural, it's procedural bananas in that case. And you know what? That's what the appellate court is trying to avoid here. This very, very involved decision was meant to basically put the judicial system, back where it should be. They are making sure that the judicial system is not made a mockery of some, politicians' whims and some politicians, legal troubles, because that should never be the case. And that's another whole question about whether prosecutors should be, politicians and legally voted upon. But that's another, legal briefs for another day.
Yeah, in that case, and I think even that case is even weirder when I'm thinking about the procedure, because I think before he was convicted, he won in the Fourth Circuit on speedy trial grounds and had it dismissed. And then the Supreme Court said, no, you can't appeal a Speedy Trial Act issue until after a conviction. So then he had to go back into custody. They had the trial. Then he was convicted. Then the Fourth Circuit was like, well, whatever, Supreme Court. Like, you're telling us that we can't do this. Well, guess what? We're letting him go now. And then the Supreme Court was like, nah, you didn't do a good job of reading between the lines of our opinion. and we're going to reverse that. So we'll just have to see what happens.
Exactly.
All right. I think the baby is growing restless.
Exactly. But let me do the sign off, and then we can talk, because then it doesn't matter, and Jason doesn't have to cut out all these adorable baby noises. But you guys, thank you so much for hanging with us tonight with a newborn and my cutting in and out. But you guys are the best. Thank goodness Brett can wax and wane poetic about any legal decision. I agree with whoever said that. Brett is as judicial as it gets. So you go on and call our episodes opinions. I will accept. Freudian slip, perhaps, perhaps not. Anyways, with that said, Brett, before we sign off, do you have anything you'd like to add?
Just that I love you, Alice. I've missed you. I'm sorry I've talked so much. I just missed talking to you so much. I had to get it all out. Love baby too.
Thank you. Well, until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
Oh, that's so awesome. Aw. Well,
you're awesome.
You're awesome. Thank you guys for joining us. I hope that was, informative. And look, I know a lot of people listening to this are upset because I know a lot of y'all are convinced that Adnan is innocent. That is not how we view this. It's not what we're thinking. We're not just saying this because we think he's guilty. I'm not saying we do think he's guilty, but that's not the point of this. This is all about doing things the right way. And I think we all agree. It's so easy to agree on this on the other side, right? Like, if the prosecutor knew for certain that Adnan or anybody was guilty and cut corners and had secret meetings with the judge and did things, below board to get the conviction of the bad guy, I think most of us would agree that's wrong. I'm sorry. We've got to go back and try that again. And that's sort of what we're talking about here. It's just on the other side. So,
yeah, absolutely. The
baby's name is not.
It's not Brittany.
Guys, Guys,
Oh
I
my
know I'm
God.
convincing, but come
did
on.
we really have to like release an episode on April 1st to clarify that her name's not Brittany?
Whatever. That's the April 1st episode. It's going to be me telling everybody that Brittany's been born.
That's actually pretty good. Done and done.
Oh, man.
Really, whatever Heather Ashley says is true. So I think we need to just change her birth certificate now to say Brittany.
Brittany, Heather Ashley, Alice Jr.
Big Mad.
Big Mad. I love it.
Big Mad. She goes by Big Mad, which is actually pretty accurate.
There you go. There you go.
Oh my gosh. Y'all are the best. I've missed you, Brett. I've missed you a lot.
I missed you too, Alice. I really have.
Yeah.
I went, I didn't even drink any of my water. So.
Oh my gosh, you're right. I drink a lot of water, so.
Well, we're not going to hold Alice. Alice, if you need to go at any time. I'll hang out for a few more minutes if anybody has any questions or anything.
Big shout out to Mr. Alice because
they want to talk about.
He was holding the crying baby for about an hour.
Aw. Do want to give a shout out. I don't think she's here, to Leah D, who of least of these podcasts, she is filling in for Alice this week. She'll be on this week's Legal Briefs, talking about an interesting case. Those of you on Patreon have already received that episode, and I hope you enjoyed it. She's great. You guys should go listen to her. It's okay, Joe. It's just, man, basketball always breaks your heart. I learned that from a young age.
It's true. Well, thank you guys. You guys are the best. I'm going to go off camera because sweet girl probably needs to hang out.
All right. Okay. I'll see y'all later.
Bye, y'all.
Love you, mean it.
Bye.
Bye.